Good morning, and thank you for joining us today for our live webinar this morning on mobile working. Our webinar will focus on remote workers overseas. We will highlight areas of immigration law, employment law, tax and social security, which will impact these arrangements both for the workers and their employees. Now, we've seen a big shift in mobile working over the past year with the coronavirus pandemic, and with many businesses choosing to close down offices, it appears that mobile or remote working will remain an option for flexible working for businesses and their employees alike. We are co-hosting this webinar today with James Cooper Preston, who are an accountancy firm based in Reading, and they have multiple offices throughout the Southwest. There will be 4 speakers, 2 from Field Seymour Parks and 2 from James Cooper Preston. I am Head of Immigration at FSP, and I will talk about the immigration implications for employers and workers, looking at workers coming into the UK and primarily those going into Europe also. My colleague Ian, who is Head of Employment at FSP, will talk about the employment law ramifications for these workers and their employees. And next we will have Jaud and Charlotte from James Cooper Preston's tax mobility team, who will then discuss the tax and social security implications for the mobile workers and their employees. And finally, we will have a question and answer session at the end for about 15 minutes. The webinar is scheduled for 1 hour in total. So you can post questions throughout the webinar, and we will deal with as many of these as possible at the end. So let us look at the immigration and the business considerations for employers in particular and their workers. So the biggest impact on mobile working will be us leaving the European Union and the loss of the freedom of movement of people. So where European employees could effectively work without seeking a visa in a European state, they must now ensure that they have a right to work in the state in which they reside, even if it's for a temporary period. So in the UK, for example, if a European national wants to continue to work in the UK, they must register and obtain status under the European Settlement Scheme before the 1st of July. That is if they're a resident in the UK before the 31st of December, and they will be eligible. Or alternatively, if they're not in the UK before the 31st of December 2020, they must secure a visa to work in the UK. So another business consideration is the removal of the European law, which is the Posted Worker Directive. So employers who send their employees to the European Union for assignments will be covered under this directive. This is likely to fall away from the 1st of January as it sits in the body of European law. So where workers have been posted to European states, we do understand there will be some transitional provisions in place for many countries. However, new arrangements will require potential registration in the host states with the immigration authorities, and there's a potential that these workers will now require a visa, which would need to be approved in advance. Another business consideration is for workers or individuals visiting Europe. Business visits would be limited to very specific activities, and there will be a restriction on 90 days in any 180 days in a 180-day period. So some planning ahead would be required for any business trips when you want to send your employees to Europe. On the other side, if European nationals want to live or work in Europe, they must register for a residence in the state in which they reside, if eligible, as soon as possible. So they will have similar provisions until the end of the transition period. So Euro UK national workers will need to look at their eligibility to register before the end of the transition. And they will also need to check on any specific information relevant in the country and where they reside. Now, the Home Office at the government website have lots of information for UK nationals who want to continue living and working in Europe, and our website has links to each of the countries if you want more information on that. Other business considerations are international agreements. There will be provisions for international agreements that span beyond Europe. So we have intercompany transfer arrangements, so movement between linked entities. There are visa routes in place for these temporary moves, but many organisations will require registration with the Home Office ahead of being able to transfer employees from Europe from the 1st of January. Many other European states have similar arrangements. So the Netherlands has something very similar, and Germany has something very similar. So again, it'll be up to you as an organisation who has PAN offices across Europe to seek out and establish whether you need to do make any registrations or make any applications to the immigration authorities in those countries. Other business considerations are fulfilment of contracts overseas. So if you're a supplier, install or repair goods, these quite often are permitted activities under the visitor route, and they are also permitted activities on the visitor route into the UK. So again, it's important if you are fulfilling contracts to supply repair goods that you check the requirements in each of the countries that you intend to send your workers. Another consideration is frontier workers. So frontier workers are those who live in one European state and then travel to work in another or multiple states. There are provisions in place for these frontier workers, and I'll come on to look at a little bit at that. I'll come on to look at that on the next slide. So there may be visa considerations for sending workers abroad, or in fact for workers coming in for short periods. So you really need to plan ahead on any trips you intend to make, and give yourself plenty of time in case the visas need to be applied for in advance. So let's identify some of the mobile workers we're actually talking about. Well, it could be any of the following. We could have UK workers or employees. So workers employed in the UK, but they've gone to live in another country, albeit temporarily, where the UK worker has been authorised to work from another country, particularly during the COVID pandemic, and this arrangement has been extended. Now, has their place of residence changed? Do they effectively have a right to work in that country? Are the tax arrangements in place? Are the social security arrangements in place? Have they effectively been establish a presence, so there are additional duties on the employer for this worker while in their new state? Other mobile workers could be those visitors coming to the UK to do some remote working. So if you do have employees coming into the UK for short periods, and whether it's due to the pandemic or not, have they established themselves in the UK and undertaking work that is potentially not permitted by the visitor route? So does that worker have a right to work in the UK? Now, this may apply in particular to a European national who perhaps doesn't have status under the European settlement scheme, or a worker who has had indefinite leave to remain, but perhaps it's lapsed in time. So if you do have visitors coming to the UK, just ensure that they do have a right to work, or they're not undertaking any activities which could put an employer at risk for allowing them to undertake work of that nature in the UK. Again, overseas visitors, those who potentially were in the UK due to COVID and stayed, again, yes, are they carrying on work that's not permitted as a visitor? Sorry, let's move on to frontier workers. So if you have frontier workers, the Home Office have launched a new scheme which opened on the 10th of December. And it's a good way for those workers to continue to come to the UK without needing to register under the European Settlement Scheme or obtain a work visa. This scheme is free to apply. However, there is one stipulation. The worker must demonstrate that the work started in the UK before the 31st of December. As I said, the application is open now, and it's if you do have workers who could be eligible, it's probably worth them looking at it now before the 31st of December. And finally, posted workers. So again, we're not sure what's going to happen from the 1st of December, as the Posted Worker Director is linked to the ability for European states to post workers across Europe. If you have any current arrangements in place, you need to assess the length of the arrangement and whether it will continue to apply post-Brexit. You also need to ensure that if you do need to make any additional applications, to assess what countries your posted workers are in and check the requirements in each of these countries to ensure that you are approved to continue and allow that worker to operate from the 1st of January. And in terms of continuing mobile working in the UK, the UK will operate a new immigration system from the 1st of January. So if your employees are mobile workers and you have a sponsor license, which will be required by organisations who want to continue employing European nationals from the 1st of January, your sponsor licence could be at risk if you fail to meet the strict duties that are required for registered sponsors in the UK, so the strict monitoring and reporting duties that you need to comply with. So the new points-based system comes into place on the 1st of January. Europeans who have not registered under the European Settlement Scheme will need a visa to work in the UK. And as an employer, if you want to employ a European national from the 1st of January, you will need to think about registering for a sponsor license. And that means you will then be able to employ workers from Europe and overseas under a skilled worker visa route. It will unfortunately be a little bit more expensive, but once the Home Office grants a license to you, they're entrusting the business to comply with immigration law, manage immigration control, and cooperate with the Home Office. So mobile working may not be suitable for sponsored workers, as it will be difficult to demonstrate that you as a sponsor are maintaining the level of control that's required by sponsors. Additionally, if a sponsored migrant spends more than 180 days out of the country, they may be unable to settle permanently in the UK after a period of long residence. Well, that concludes my piece. I will now hand you over to my colleague Ian, who will discuss the employment law implications for mobile working.
Thanks very much, Imelda. Good morning, everyone. So as Imelda helpfully introduced me earlier on, my name is Ian. I head up the employment law team at Field Seymour Parks. And I'm going to run you through some of sort of the employment law implications of remote overseas working. The focus I'm going to look at is in particular on people who have originally been UK based and have subsequently gone on to work remotely or request working remotely. A lot of the things I will talk about would apply the other way around, i.e. people who have been previously based overseas coming into the UK, but just for the sake of ease, I'm going to focus on the previously UK based moving to sort of remote working overseas. As Imelda hinted at, we're seeing a lot more of this, particularly with the COVID restrictions. So whether it is people wanting to work in their sort of home countries or it's quarantine rules, remote working is more common generally and certainly more common over international borders as well. So if we look at the starting point, if this is sort of an employee-driven request, the first thing to think about is whether or not you've got an obligation to agree to it. And the first thing to do is to have a look at the employment contract and just to see what it says in there about place of work. Obviously, if this is a new request and it hasn't been something that's been anticipated, it is probably likely that your contract is not going to allow the employee to home work from overseas. And if it doesn't, then in short, you're under no obligation to grant that request. But what I would say is you need to be careful in considering it, because you have to make sure that you're not acting in a manner which is going to undermine the sort of relationship of trust and confidence between employer and employee, which can give rise to claims if you do, such as constructive dismissal. And also just be careful that it hasn't been requested as a sort of a flexible working request, because if it does tick those boxes, then there's a formal process you'll have to follow to consider it. And there's certain sort of statutory grounds on which, if you're not going to accept it, you have to state as your grounds for rejection. So bear those in mind. Aside from that, obviously you've got the practical implications, which you will differ depending upon the nature of the role, nature of your organisation, but obviously you need to think about those things. Time differences, how are you going to monitor and supervise, and also some of those sort of classic sort of home working, remote working issues anyway, you know, equipment, suitable environments, things of that nature. But if we assume that those practical issues can sort of be overcome, the next thing you then need to look at is a contractual amendment. So again, assuming that you don't have a clause that allows for that sort of overseas home working, you're going to need to vary the employment contract. And again, you need to go back to the original contract just to check whether or not there's any specific provisions in there in terms of how that variation is carried out. So you may have a variation clause in there that may talk about has to be signed by both parties, has to be served in some way. Check that out, because if you're going to the trouble of doing an amendment, you want to make sure that it's going to be binding. The other things to get in your contractual amendment, well, you need clarity as to how long the arrangement is going to last for. Is it temporary? Is it permanent? Can it be brought to an end on notice? Can it be brought to an end due to maybe some form of breach? So if there's a breach of your home working policy, do you want the ability to bring it to an end and require them to return to their previous place of work? If there's any change in hours or role, obviously you need to detail that as well. And data protection, which I'll talk about a little bit more later on, but you may need to have specific contractual provisions in there. And equally on health and safety, because you're still going to have those obligations as an employer, and you're going to need to think about how you're going to comply with those despite your employee not being physically based maybe in an office environment. And you may want some contractual clauses to try and get the employee to take greater care for their own health and safety. Obviously, if you've got a home working policy, you're probably going to want to incorporate that by reference, and if not, you're probably going to want to include some additional contractual clauses dealing with some of those things around home working. So those are the main things around sort of contractual amendments. You do have, in any event, which kind of overlaps with that, some legal obligations when you've got a change in circumstances such as this. So where you've got an employee who is now going to be required to work overseas for more than 1 month continuously, you have a legal obligation under Section 1 and Section 4 of the Employment Rights Act to issue them a revised written statement. And that has to include, again, the period of time that's going to be required for, the currency in which they're going to be paid, any additional remuneration and benefits that are linked to it. So if there are payments that are going to be made to cover moving expenses, things of that nature, that would all need to be in there. And again, terms relating to return. So that could be the notice that is required to compel the employee to return, or it could be, again, sort of removal arrangements, things of that nature. And you have to issue that at the latest by the day the employee leaves the UK. In reality, because it's probably tied in with your contractual amendments, you're going to want to do it a fair bit before that, because you're going to want to have this all nailed down before the employee is actually heading off to work overseas. Obviously, with COVID, that wasn't always possible, but going forward, that's definitely what you should be aiming for. The other thing then to consider is kind of sort of on the UK legal requirements is whether or not they're still going to qualify for protection under sort of English and UK employment law. And it's a relatively complex subject, because the right of employees to bring claims under English employment law differs depending upon the right that they're trying to enforce. So if it's an unfair dismissal claim, the test for that is different, for example, to an Equality Act claim, a discrimination claim. But the general position is the fact that someone is merely sort of an expat, i.e. the fact they used to work here and now work overseas, is not normally enough. There has to be a sufficiently strong connection or link to the UK to make it appropriate for an UK tribunal or court to sort of allow the enforcement of these sort of statutory rights. And it's not linked necessarily to a mere period of time. You have to look at the whole factual circumstance. So you'd look at where the employee is living, what currency they're paid in, the period of time they've been overseas, how is their pay structured? Are they, for example, still pay structured within a sort of UK pay scale, or is it something unique to the role? Tax and social security, which my colleagues will talk about in due course. Organizational structures, who are they reporting into? Are they reporting into the UK? And what's the purpose of their work? Are they, for example, still working primarily for a UK business, or are they actually setting up a foreign business, a sort of overseas entity? So that's the UK sort of legal requirements. The other bit that you need to think about is any sort of local requirements. And this is where you need local advice ultimately, because employment rights in different countries obviously differ, and also their sort of jurisdiction differs between countries as well. So you can't say there's no sort of one rule fits all to say whether or not the sort of an employee will qualify for sort of local protection just because they're based in another country. Few things to note though is often in an employment contract you will have a clause that deals with contractual disputes. So you'll have a clause that says this contract is governed by the laws of England and Wales and the courts of England and Wales. That may be determinative for contractual disputes, but that doesn't necessarily mean that that will apply for sort of statutory protection. So in the UK, for example, your unfair dismissal, your discrimination protections, national minimum wage, etc., and the equivalents overseas, that won't be determined solely by that clause in that contract. You can't rely upon that wholly. And also, even if the parties have kind of agreed that the employee will, for example, not get protection under the sort of the local legislation, that's not necessarily determinative either. And you run the risk with these things, unless you sort of get advice up front and you know where you stand, that you can sort of be caught in two positions whenever you're trying to manage the employee. Do you follow the UK legislation? Do you follow the local legislation? And it can get very messy because you can sometimes be trying to comply with two entirely different sets of legislation. So do take local advice. Data protection. Well, there's two bits to this really. The first bit is your sort of normal requirements. So if you've got a bit like someone home working in the UK, you need to ensure that personal data is kept secure, it's only used for the purposes it's meant to be, used in accordance with your privacy notices. So you've got all your normal requirements. You're going to have to make sure that still works despite the change in location. Equally, I should flag that if you are doing sort of additional monitoring, maybe through IT or something like that, that's something you'd need to cover off or make sure is covered off in your employee privacy notice. But the other sort of requirement or element to consider is where you've got personal data that is moving outside the EU or outside of one of the countries that's got sort of an adequacy decision, i.e. they've got equivalent safeguards in place for personal data. And under sort of the GDPR, if you read that, when you've got a transfer of data outside of those areas, there is a requirement in there for additional safeguards, so standard model clauses and things of that nature to make sure that that data is kept secure. But the ICO guidance in the UK suggests that you don't have to have additional safeguards, provided you're doing all the normal things, provided that that personal data is only passing to your employee. So that's good news. It makes it easier, but you do need to be careful that that employee is then not transferring it on to other local entities. So if they're running a business in a different jurisdiction, you just need to make sure that they're not then passing that personal data on, because as soon as you do that, that then triggers additional responsibilities. So a few final matters to run through quickly, just things to think about. Insurances. You might have insurance that is for the benefit of the company, that maybe covers you for accident, illness, key man insurance, things of that nature. And you might also have employee benefits, private medical, life assurance, group income protection, etc. You need to check the terms of those policies to see if they're going to be impacted. And obviously, if they are, you might need to communicate that and agree that with the employee. If your employee is operating a business in a different jurisdiction, that might trigger other local requirements in respect to sort of corporate law. If you're seen as operating a business in certain jurisdictions, there are additional obligations on you. And then finally, just be aware of the Posted Workers Directive, which Imelda helpfully flagged earlier on. From an employment law perspective, it can guarantee sort of minimum levels of employment protection. If there's a transfer between companies in the EU, we're anticipating, subject to any deal that Boris secures, that will fall away after the end of this month. But obviously anything before then, or indeed if Boris does deliver a deal that changes things, then that's something to consider as well. That's whistle-stop tour of the employment bits, and I will hand over to Jaoud now to talk about some of the tax implications.
Thank you, Ian, and good morning, everyone. So I'm Jawed Shakt from James Cooper Cresson, and I'm a senior tax manager in the Global Mobility Tax team. And today, with my colleague Charlotte First, we will cover the UK tax and social security implication around your mobile workforce. So alongside immigration and employment law consideration, and whilst you may want to accommodate your employees' requests with regard to working remotely overseas, the UK tax and social security implications should not be overlooked. The first point you need to consider is your employee's residence position. Different countries have different tax rules to determine tax residence, so you always need to seek local advice in the specific country. Don't just assume that one rule will fit all countries. In the UK, we have the statutory residence test to determine someone's residence position. This is a detailed document of about 100 pages and can be quite complex. So it was introduced by HMRC on the 6th April 2013 for the tax year 13-14 onwards, and has been very useful in sending out the residence rules. It is really important to understand that an individual's residence position has a direct impact on their tax position. So the test essentially has three parts to it: the automatic overseas test, the automatic UK tests, and the sufficient ties test. Essentially, you will be considered non-resident in the UK if you meet one of the automatic overseas tests, or considered UK resident if you meet either one of the automatic UK tests or the sufficient ties test. So the sufficient ties test determine residence based on the number of ties to the UK, for example, family, accommodation, or work tie, in conjunction with a number of midnights spent in the UK, and this test often catch a lot of people who do not get caught by the automatic UK tests. So the test is a bit like a flow chart that you follow through until you meet one of the tests. So once you have met one of the tests, you don't need to continue any further. It is also possible in some countries, like the UK, to be resident for part of the tax year and non-resident for the rest of the tax year. So this is most likely when someone arrives or leaves a country partway through the tax year. This is called being a split year resident, and is a useful concession to ensure that income received in other country before arrival or after departure is not taxed twice. So the statutory residence test analyzes an individual's presence in the UK, especially how many days they spent in the UK in any given tax year. So if we take a look at what a day is, first of all, essentially a day is when an individual is in the UK at midnight. However, there are certain scenarios in the statutory residence test which allow for days to be excluded from a taxpayer's annual day count. And these are what we called exceptional circumstances. Now, exceptional circumstances will be considered exceptional when the situation is beyond the control of the taxpayer. So whether or not the situation will be exceptional is based very much on the fact and circumstances, and HMRC places a lot of emphasis on this. So to be considered exceptional circumstances, the taxpayer must have absolutely no choice in the terms of the time they spend in the UK. HMRC have issued an updated guidance, and that these exceptional circumstances will extend to the impact of the current pandemic. And they gave a number of specific examples which would qualify as exceptional. The main example include having to quarantine in the UK or advised by a government to not travel. But this list is not exhaustive. So now the issue with the exceptional circumstances, and one which is ever more prevalent in the midst of the pandemic, is that they are limited to just 60 days. And HMRC's last updated guidance does not intend to extend these 60 days. So we can take our exceptional days into account for a lot of days, but not all of them. For example, whilst an individual may be able to take advantage of the 60 days under the exceptional circumstances, there is no extension to the 30 workday rule, and therefore working in the UK for more than 30 days runs the risk of triggering the residence position. So lastly, it is possible to be resident in 2 countries and at the same time. So this is called dual residence and can cause double taxation problems if both countries seek to tax the same income. The double tax treaty between 2 countries can be used to elevate the double taxation by determining out of the 2 countries where someone is treaty resident. It is important to look at the specific treaty between 2 countries as each treaty can be worded differently, but generally a treaty will determine treaty residence by looking firstly at the permanent home, secondly as a center of vital interest, so both financial and social, thirdly the habitual abode, and lastly the nationality. So again, it is a bit of flow chart, and if the first criteria cannot be met, then you move on to the second one. So once the employee's residence has been determined, then the employer may need to make PAYE adjustments to ensure the correct tax treatment if the employees remain on the UK payroll. Firstly, when an employee is sent on assignment outside of the UK and they are no longer a UK tax resident, a no tax or NT tax code needs to be applied. Applying a NT code means that the employer does not have to operate PAYE, so pay as you earn, on employment income relating to non-UK work duties. However, this does not cover national insurance contribution, and will have to be reviewed separately. So my colleague Charlotte First will be covering this in the later slides. NT codes should take effect from the departure date to prevent double taxation. So it is imperative that you complete the relevant forms and send them to HMRC prior to the employee commencing their assignments. HMRC has advised that a letter including the relevant information will suffice. However, we can see in practice that in some cases, HMRC are still requesting a departure form named P85 form to be completed. So any substantive UK duties will be taxable whilst non-UK residents, whereas incidental duties will not. Please note that HMRC will consider the quality rather than the quantity of the duties. So there is no specific number of days before duties are considered substantive. So the main rule of thumb is that if the work done in the UK is subordinate or ancillary to that done overseas, it may be incidental. If the work done in the UK is broadly the same kind of that done overseas and of equal importance, it's likely to be substantive. So if your employee anticipate or you anticipate that your employee will have substantive UK work days, a Section 690 agreement should be applied to tax an estimated percentage of work days to be performed in the UK. And a UK tax return should be filed by the individual to report the actual position. However, the Section 690 does not cover employees who are treaty non-resident in the UK. Finally, under certain circumstances, a net of tax credit scheme could be applicable. So the main purpose of the scheme is to give provisional relief for double taxation to employees who must pay both UK tax and foreign tax from the same payment of earnings. In short, UK PAYE is deducted as normal. However, a portion is sent to the overseas tax authority and only the balance is sent to HMRC. The foreign tax that the employee is liable to pay is deducted from their existing UK PAYE liability and paid to the overseas tax authority. The credit available under the agreement is restricted to the amount of UK PAYE. So if the foreign tax exceeds the UK PAYE, then no UK PAYE will be due for the pay period. So the main benefit to the employee is that they do not suffer both UK PAYE and overseas withholding tax on the same income in the payroll. The UK PAYE adjustments is one thing. However, it is important to not forget employer and employee obligation in the overseas location. So we strongly recommend considering if the employee will become resident overseas and if they do not trigger residence in the overseas jurisdiction, then it is likely that it will be like a tax return required. There may also be a requirement for the employer to register locally or to operate a payroll to withhold tax and social security. The answer to this question vary from country to country, so it is important to seek local advice. And at James Cooper Question, we work with different international tax advisors, and we can provide any contact needed in any countries. Last point, but not the least, is now you can be aware if like a business were to operate within another country, that country may seek to tax the profit that arrive there. This could potentially arise either by having a corporate tax residence or a permanent establishment, in other words, PE, in this country. So while the rules on PEs varies to an extent from one jurisdiction to another, typically and consistent with the OECD Model Convention, a permanent establishment in a jurisdiction will arise where an entity has a fixed place of business or a dependent agency. An employee starting to work from another jurisdiction for a long period may give a rise to a permanent establishment in the employee's home jurisdiction as a result of there being a fixed place of business. So here again, we strongly recommend that the relevant tax treaty should be reviewed to determine the overall residence of the company. It is important to undertake a permanent establishment risk analysis to ensure that a permanent establishment or a corporate residency has not inadvertently being created due to the activity of some of your employees working remotely. An analysis needs to be undertaken on a case-by-case basis, given full consideration on the employee's duties in which jurisdiction they are performed. This analysis will help to reduce first the risk of unexpected underpayment and also interest and penalties due to failure to comply with the jurisdiction in question. So now that you know more about the residence tax rules and the tax consideration, employee and employer obligation, I will just hand over to my colleague Charlotte first. We will cover the social security implication. Thank you, everyone.
Thanks, Jawad. So I'm just going to start by mentioning that, as Jawad said before, the social security position doesn't necessarily follow the tax position. So it is something that needs to be considered and analysed separately. Today I'm going to start by running through the current social security rules for cross-border workers, so we know where we stand. Then I'm going to look at remote workers specifically, and finally how Brexit might change things. So currently, as it stands, the rules for social security for people moving in and out of the UK on short-term assignments or business trips broadly fall into three categories. The first category concerns movement between EU and EEA member states. For those individuals, the usual position is that you apply for an A1 certificate of coverage from your home country, and that would allow you to remain in your home country's social security system whilst you're overseas on assignment or on a business trip, and exempt you from paying local social security. Those certificates are usually issued for 2 years initially and can be extended to cover 5 years maximum. There is also the possibility of applying for a multi-state worker A1 certificate, and that is to cover individuals who routinely work in 2 or more EU or EEA member states. Usually for those individuals, they pay social security in the state where they're habitually resident, as long as they're working at least 25% of their time in that country. And if not, usually it falls to the country where the employer is based. The second category of countries are countries with which the UK has social security agreements. So, for example, the USA or Japan. in that case, the position is fairly similar to the first category. You just apply for a certificate of coverage under the Social Security Agreement, and you remain in your home country system. The final category are countries with which the UK does not have a Social Security Agreement. In those cases, for individuals coming to the UK on assignment or for business trips, there is an exemption from national insurance for the first 52 weeks, and then NI will kick in at that point. And for outbound individuals, there is an ongoing national insurance liability, usually for the first 52 weeks, and then it will cease. So these rules in general seek to eliminate the risk of a double Social Security liability. Now, moving on to look at remote workers specifically. Usually, if you have employees leaving the UK to work remotely overseas, they would not normally remain in UK Social Security unless the employer is carrying out business in the other country and is specifically sending the employee to work overseas on a temporary assignment. We have seen some employers recently, for COVID reasons, framing remote working scenarios as a temporary assignment where it is not going to be carrying on long term, and it's a fairly low risk approach. The other option for getting a certificate of coverage in the UK would be applying as a multi-state worker, and that is possible where an individual was working at least 25% of their time in the UK in the previous year and would expect to do so in the following year. That would allow them to remain in UK Social Security on the basis that the UK remains their country of habitual residence. For all other cases where it's not possible to frame the remote worker as a remote working situation as a temporary position, the individual would be expected to pay Social Security in the overseas country, and that obviously might entail some registration and potential withholding requirements for the employer. That will vary from country to country, so local advice should be taken. Now, moving on to look at how Brexit might change the position. That will very much depend on whether or not there is some form of deal. So the UK and the EU are currently negotiating a new Social Security coordination agreement. But at the moment, EU rules are still domestic law in the UK and will continue to determine NI policy. That is likely to change if there is no deal. And in that scenario, you'd have to look at how the withdrawal agreement might cover those people in a cross-border situation at the end of the transition period, so the end of this month. Recent HMRC guidance has said that if a cross-border situation commenced up to and including the 31st of December 2020, the individual should be covered by the existing rules, and HMRC will continue to issue A1 certificates for the normal 2-year period in those scenarios, and would expect to be able to extend those certificates as usual, provided the situation continues without interruption, and that is because there will be grandfathering rules in place. They have said, however, that they would not expect to issue A1 certificates with a start date from the 1st of January 2021 onwards, unless it can be established that the individual will be covered by the withdrawal agreement, which they potentially would be if there is a deal. However, they've also said that their advice is that if it gets to a point where you would normally apply for an A1 certificate and negotiations are still ongoing around whether or not there'll be a deal, then you should apply for an A1 certificate in any case. So I think that's definitely the situation we find ourselves in at the moment. So what will happen beyond the 1st of January if there is no deal for those people that are not covered under grandfathering rules? Well, the UK does have some social security agreements with some EU countries that underlie the EU rules. We by no means have them with all countries. For example, Poland is a big one where we don't have an underlying agreement, and the agreements we do have in place are quite old. Many EU countries have taken the view that these underlying social security agreements are outdated and no longer apply, but we understand that the EU has taken legal advice, and that has concluded that the social security agreements will continue to apply until they are removed from the statute book. In practice, as I've said, they are quite old and would really need updating because they don't meet the requirements of today's globally mobile workforce. For example, some of the underlying agreements only allow for a 6-month period of coverage, and some have other requirements. So you would need to look at the individual agreement. Otherwise, in all other cases, the 52-week rule would apply, which means that inbound assignees or business travellers are exempted from national insurance for the first 52 weeks, but it does open up the possibility of potential double social security liability for UK outbound travellers. So finally, what will happen to any UK work days for people remotely working overseas? So if they have managed to remain under UK social security via an A1, whether that's a posted worker or a multi-state worker A1, then that's not a problem because they're already paying UK social security. If they are paying locally, then strictly an A1 would be required to cover any workday in the UK from day one, and HMRC can request that. In practice, however, periods up from 2 to 6 weeks can usually be ignored, although it's yet to be seen whether that will be more strictly enforced in the event of a no-deal Brexit. If there is a no-deal Brexit, as I've alluded to, there is a possibility of obtaining a certificate of coverage via one of the underlying agreements, whether that's an old agreement or perhaps the UK will negotiate new agreements or update the existing agreements, and otherwise the 52-week rule would apply. The final point to mention regards multi-state workers, as they've not been covered by any recent HMRC guidance or EU guidance around Brexit. So that could be a big problem. It could open up the possibility of individuals being liable to social security in multiple countries, and it's not clear whether that would be calculated based on total income or only source income from the specific country. The only real way to manage that practically would be to limit or amend travel patterns so that the individual avoids being a multi-state worker, perhaps only travels between 2 countries, reduces their travel to business trips only. I think at the moment with current COVID restrictions that's quite possible, but perhaps not as practical if travel patterns return to usual. So as you can see, the post-Brexit social security landscape is not exactly clear, and it remains to be seen how some of these issues will be dealt with in the event of a no-deal outcome. In practice, as most remote workers, if they're going to be working long-term remotely overseas, will be liable to social security in the local country in any case. So there's perhaps a bit less impact. I think that's everything. So we're going to open up to the questions that you've submitted, and I'll hand back to Imelda.
Thank you, Charlotte. Thank you, Ian, and thank you, Jaud. Well, let's see, have we any questions? We have a couple. A UK employee is resident in the Netherlands. What do we need to do to ensure we comply with the law? Well, I think that affects all of us, guys. Well, I'll go on the immigration part first, if that's all right. So obviously, if that person wants to come to the UK at some point, they would either need to have registered under the European Settlement Scheme, if they can show residence in the UK, or they could utilise the Frontier Worker Permit Scheme, which was launched in December, so that they can continue to come to the UK without requiring a visa. Obviously, the UK employment would have to be demonstrated as being in place before the 31st of December to be eligible under this route. Is there any other aspects from the other panelists that they could add to this?
Well, go on, Joe, after you.
Yeah, sorry, it's just about more tax perspective. So under the premise that the individual would be employed in Netherlands by under like an UK employment contract, there's like different points we need to consider as like an employer perspective. So it's possible to pay the individual via the UK payroll, but they will need to check if like the payroll provider we are able to make, for example, back payments in the UK bank account, but also the individual probably should be subject to Dutch social security. And so the UK payroll can be run with a code named X for the social security. maybe Charlotte will speak about the A1 certificate after on, but about the tax perspective, as I mentioned before on my slide, on the basis like the individual will not be UK tax resident, and if there is no UK work days, you can apply for anti-tax code. If there is any UK substantive work days, as I mentioned before, you need just to anticipate the substantive UK work days and apply for Section 690 agreements just to anticipate the percentage of UK tax. And maybe Charlotte, for Social Security, you can add something.
Yeah, I think if we're assuming that the individual is working long-term remotely and it's not some form of temporary assignment, I agree they should be paying Dutch Social Security, so you can run an X code in the UK if they're keeping them on UK payroll. Sometimes we're advised to get an A1 certificate from the Netherlands just to prove the position to HMRC, but in practice, if there aren't UK work days, it's not something we usually find that HMRC request.
Okay.
Yeah, so
And
I'll just finish off to say, I think the issues from an employment law perspective turn upon the nature of that relationship. So how long-standing it is, what's the connection to the UK, what's the connection to the Netherlands. It sounds though from the question you've got someone who is permanently based in the Netherlands, just maybe working for a UK company and under a UK contract, and in those circumstances it's highly likely that you're going to need to be compliant with the local legislation, so I suspect that is a case of taking local advice. I was incidentally speaking to one of our colleagues in the in our international network in the Netherlands the other day on health and safety in the Netherlands, and they have stricter requirements for home working than we do in the UK here. There's much more provision of things like ergonomic chairs and desks, etc. Whereas in the UK, yes, you need to do risk assessments, but it doesn't seem to go quite as far. So it's things like that you could quite easily fall foul of. So yeah, one to definitely take advice on.
Yes, there's lots to consider there. Thank you for that. We have one other question. It's again my fault to you, Ian. Apologies. We employed a Bulgarian national 2 years ago and they don't come to the UK. Should we keep them employed or do we need to look at some other kind of worker arrangement? Well,
I suspect it's similar issues to our Dutch resident, in that if you've got someone who is has been for a period of time and looks like he's going to continuously to be based overseas, that the mere fact that they are working for a UK company does not mean that they're not necessarily going to qualify for local employment law protections, and it's these types of scenarios where we see that most problems, I guess. And we've certainly had situations where someone has been taken on under a UK employment contract, maybe with an intention they're going to be in the UK, but it never actually happens for one reason or another. And that's when it can get a bit messy, because you're probably treating them as a UK employee, and you may well be inadvertently breaching all manner of local legislation. And if that relation, particularly when if cynic in me says when, but if the relationship turns sour, that's when often it comes to the fore and you can get seriously caught out. So on that one, again, I suspect that they're going to qualify for local protection. I'm not a Bulgarian law expert, I have to say, but my colleagues in the international network would be. But yeah, it's one I'd say take advice on.
And I think on the immigration side with that, I do think that if they do try and come to the UK and they don't have any kind of visa, any kind of permission under EU law, then there could be questions at the border as to why they're entering the UK. And by virtue of having a UK employment contract, working in the UK, they could be deemed to be working here without permission. So there may be issues. We don't quite know how and the frequency at which workers will be stopped at the border by customs control. But there is a possibility that could happen. I think we have another question here. We have time for one more, I think. We have a Slovakian national who's been resident and working in the UK since 2018. He returned to Slovakia at the beginning of the pandemic temporarily, but is still there, returning in January 2021. He's working for a UK company. How would this impact his tax and his UK employment contract. So he's been working since 2018, returned for the pandemic, and he will return in 2021. So he's been officially outside of the country for a number of years.
Joe, do you want to start on the tax point? Or
tax
Yeah,
part?
no problem. So because he worked in the UK since September 2018 and just he has been outside just for the pandemic, like the first thing is just to look at like the residence position of the employee when he will be back to the UK to make sure if he's UK resident or not UK resident. As I mentioned before, it will be we need just to look at if he being like dual resident or not. So we need to check about like the double tax treaty, and if he received and if he remained UK tax resident for the 2021 tax year, and for the full tax year, we need you to check if there is split year tax treatment, and the split year tax treatment could exclude like the part of income received during that period from like March when the pandemic starts to December. But if we can apply for any cases for the split year tax treatment, that income should be reported in the UK and via the tax return. So any regularization should be under the tax return, and probably we need to file a tax return when like the tax year will be ended. And also we need to look at any advice in Slovakia, because maybe you need to pay any tax on UK employment received when you was and is currently based in Slovakia. So we need to look at local advice to make sure that local tax has been paid or not, and probably a Slovakian tax return should be submitted too.
Thank you, Jared.
And on the social security side, on the basis that it's a temporary move to Slovakia, and that the employer doesn't have any ongoing business in Slovakia, probably the best position would be to apply for a multi-state worker A1 to cover that temporary period on the basis that he'll be returning to the UK, and that is the country of habitual residence. So yeah, that application can still be made for backdated to cover the period in Slovakia.
So that would need to be done before the 31st, Charlotte, December.
It's a start date earlier, so I don't think it specifically matters. It should be issued even retrospectively. So yeah, that should be fine, and he can stay in UK national insurance.
Okay, and Ian, have you something to add on the contract?
yeah, I think the hope would be this is slightly lower risk of complications than maybe the first couple of scenarios, in that it appears to be a short-term assignment. It appears to be pandemic related. You would hope, therefore, that there is still a much stronger connection to the UK than maybe to the local law. It was still one I'd say take local advice on to be on the safe side, but I think it is it's hopefully lower risk, and if it is all amicable and they are coming back shortly, then hopefully you'll be back onto sort of a level footing with it, really. And if you haven't already sort of put, I don't know when they're coming back in January, but if you haven't sort of put contractual arrangements, etc., in place, if they're coming back very shortly, it may well be the case that's just, from a practical perspective, not sensible. You may just be causing more issues than you're solving. But if they are going to stay out for any further length of time, then it's going back to those principles I talked about earlier on, making sure that the amendment's in place, make sure that you've got proper agreement, etc.
Thank you very much, all. Well, I think we are now coming to the end, so it just leaves me to say thank you very much to you all for joining us for our webinar. If you require any further information on the topics discussed, our contact details are on the slide. We all have international contacts for tax, immigration and employment. So again, if you have specific needs for any European countries or beyond, we can direct you to the appropriate advisors. And that leaves me now just to say I wish you all a very happy Christmas, and we'll be in touch soon. Thank you. Bye-bye.
Thank you, everyone.
Thank you, everyone.